Despite its illegal status under federal law, marijuana has been legalized in Massachusetts. This conflict presents new and unique challenges to employers who must balance complying with federal laws and providing a safe workplace on the one hand, with preserving the rights of employees to use marijuana for medical and recreational purposes. Today, we will discuss the relevant federal and state marijuana laws and their effect on an employer's rights, obligations, and workplace policies. Similarly, we will discuss the proactive role employers can take regarding opioids in the workplace. As noted by the National Safety Council, employers who have strong workplace policies, education, health benefit programs, and well-trained managers create safe and healthy environments in which both employees and business thrive. All right, so it helps if we're all talking about the same thing and have the same definitions. So I'd like to start out by talking about what marijuana is. I'm sure most of you are familiar with it, but just so that we're all on the same page, let's just briefly describe what we're talking about. So marijuana can also be called weed, pot, dope, or cannabis, and it's the dried flowers and leaves of the cannabis plant. Cannabis is a broad term, and it describes the different products that come from the cannabis sativa plant, including marijuana and cannabinoids. The terms cannabis and marijuana have different legal meanings and significance. So from a legal standpoint, the word cannabis can describe a legal plant, like industrial hemp, or an illegal one, in some cases like marijuana. All marijuana is cannabis. However, the opposite is not true. Not all cannabis is marijuana. The term medical marijuana refers to the use of cannabinoids and is used for its therapeutic effects, including pain relief, control of nausea and vomiting, appetite stimulation, anxiety reduction, and sedation, as well as the treatment of spasticity, glaucoma, and movement disorders. Marijuana contains mind-altering or psychoactive compounds like THC, as well as other active compounds like CBD that are not mind-altering. So as we've just noted, marijuana is illegal under federal law. There are two primary sources of cannabis or marijuana law. We have the Controlled Substances Act and state law. The Controlled Substances Act breaks controlled substances into 5 schedules ranked from the most, Schedule 1, Schedule 5, based on its potentially harmful nature. So we see that marijuana is a Schedule 1 controlled substance under the Controlled Substances Act, which means that, as defined, it has no currently accepted medical use in treatment and high potential for abuse. And consequently, under the Controlled Substances Act, it's a federal crime to use, possess, or distribute marijuana. Marijuana can be ingested and used in a number of different ways. You can see the different ways on the screen, and how you take it is up to you. Each method works differently in the body. For example, smoking or vaporizing will make you feel the effects of cannabis almost immediately, while it can take up to 2 hours for edibles to take effect. When it's smoked, it can be inhaled through a device called a vaporizer that turns it into a mist. It can be eaten, for example, in a brownie or a lollipop. It can be applied to the skin in a lotion, spray, oil, or cream. And you can also place a few drops of the liquid under your tongue. All right, so why should an employee care about marijuana? Well, as we've discussed, cannabis or marijuana can impair cognition, attention, and intellectual performance, though the effects are reversible. In some individuals who are at risk, it can unleash psychotic states. Let's now switch briefly to opioids. Opioids are a narcotic that are derived from the opium poppy or synthetic version and include the illegal drug heroin, synthetic opioids such as fentanyl, and pain relievers available legally by prescription. And you see examples. You probably recognize some of the more common names. In the recent years, the number of prescriptions has gone up dramatically, along with the number of opioid-related deaths. Opioids are highly addictive. Again, why would you care as an employer? You can see all the number of potential impacts that you can have from opioids. I will note that presenteeism refers to the practice of coming to work despite illness or injury, and it often results in reduced productivity. Heroin and prescription opioids bind to the same brain receptors. This action can cause a possibly sudden change in a person's mood, awareness of pain, breathing. Prescription opioids and heroin can produce similar effects. As you can see from this graph, marijuana is the most widely used drug in the country. All right, so let's talk a little bit about legalization of marijuana. So a total of 33 states, the District of Columbia, Guam, and Puerto Rico now allow for comprehensive public medical marijuana and cannabis programs. Massachusetts allows for the use of marijuana for medical and recreational use, as we'll discuss in more detail as we move forward. Legalization allows protection from criminal penalties for using marijuana for medical purposes. Access to marijuana through home cultivation, dispensaries, or some other system is likely to be implemented. A number of states also allow or permit certain low THC and CBD products for medical reasons in limited situations or as a legal defense. Those programs are not counted as comprehensive medical marijuana programs. Recreational use of marijuana is now legal in 10 states and the District of Columbia. Not surprisingly, with more widespread use of marijuana, we're now seeing more employees testing positive for marijuana at work. As you can see from the screen, marijuana positivity has continued its 5-year upward trajectory in urine testing for both the general U.S. workforce and the federally mandated safety-sensitive workforce. You can see that positivity rates have increased in those states that have enacted recreational use statutes, including Massachusetts. This reinforces the need to be vigilant in the workplace. And it's worth pointing out that there currently is no reliable test to determine if a user is impaired or for how long that user remains impaired. Okay, so how is the Controlled Substances Act interpreted at the federal level? As we noted again, marijuana remains illegal at the federal level. During the Obama administration, the so-called Cole memo was issued, which in essence said that the Department of Justice wasn't going to treat enforcement and prosecution of marijuana users as a priority. They were going to leave that to the states. Instead, they were going to focus their efforts on preventing marijuana sales to minors and stopping drug cartels. On January 4th, 2018, President Trump's administration rescinded the Cole memo. U.S. Attorney General Jeff Sessions called this policy shift a return to the rule of law. On the other hand, passed in 2014 and renewed in 2018 is the Rohrabacher-Farr Amendment, which prohibits funds provided through the Department of Justice in the Appropriations Act from being used to enforce the Controlled Substances Act in states where medical cannabis is authorized. So where does that leave us? Somewhat of in a state of flux at the federal level as it relates to enforcement. All right, so let's return to the issues of the workplace. So what's our conflict? Well, as we noted at the beginning of this presentation, employers must balance complying with federal laws and providing a safe workplace on the one hand with preserving the rights of employees to use marijuana for medical and recreational purposes. So some of the issues that come up that we're going to discuss in more detail. Can you as an employer object to your employee's use of marijuana at work? Can an employer refuse to hire an employee because they admitted to using medical marijuana? Can an employer fire an employee because they fail a drug test because of medical marijuana, even if the employee was never found to be impaired? So what does the Massachusetts medical marijuana law say? Well, in order to qualify for medical marijuana, patients must have a diagnosed ailment that is on their state's list of qualifying medical marijuana conditions. With the recommendation of a local physician, a qualified patient can obtain a medical marijuana card or authorization to visit dispensaries and purchase medical marijuana products. Now, recall that marijuana laws are about decriminalizing marijuana use. They don't speak, in Massachusetts at least, to the issue of employers and employees in the workplace. So here we have the Act, and it notes that you must be a qualifying patient. We define qualifying patient as a person who's been diagnosed by a licensed physician as having a debilitating medical condition. And then we see in C what those debilitating medical conditions mean. Now, importantly for our discussion, law also states that nothing in this law requires any accommodation of any on-site medical use of marijuana in any place of employment. Nothing in this law requires the violation of federal law or purports to give immunity under federal law. Consequently, you can immediately terminate for marijuana use in the workplace, as we'll discuss in more detail. But what this says, in essence, is you don't have to accommodate the use of medical marijuana in the workplace. Now, let's talk briefly about recreational marijuana. Now here, again, we have the law, and in this time it specifically states, this chapter shall not require an employer to permit or accommodate conduct otherwise allowed by this chapter in the workplace. It shall not affect the authority of employers to enact and enforce workplace policies restricting the consumption of marijuana by employees. And as we'll talk about in more detail, this allows for the use of drug-free workplace policies. So the Marijuana Act expressly permits employers to prohibit employees from using or being under the influence of marijuana in the workplace. But it does not address whether an employer can regulate an employee's lawful use of marijuana off duty. This is still an open question. Neither the law nor the applicable regulations address employer-employee rights in the context of recreational marijuana, and it's too soon for the courts to have addressed this matter. If you're an employer and you wish to prohibit off-duty or off-site recreational consumption, you should expressly state that such conduct may result in discipline or termination of employment. That language should be in your drug-free policy. Massachusetts, unlike a number of other states, has no law that protects employees' lawful off-duty conduct. To contrast that, a number of states do allow for that protection. For example, in Colorado, they have a statute that prohibits terminating an employee due to participating in a lawful activity while not at work, for example, smoking. However, a leading Colorado case found that an off-duty employee who consumed marijuana to treat painful muscle spasms caused by his quadriplegia was not protected by Colorado's lawful activities law, because to be lawful, an activity must be permitted by both federal and state law. And as you recall, since marijuana is illegal at the federal level, it's illegal at the state level in Colorado, and there's no protection for lawful off-duty activities as it relates to marijuana. So, situation with recreational marijuana and off-duty, we know that there's no protection under that lawful activity law, but what about a breach of privacy? Would that be successful? Who knows? Time will tell, but this is why it's important that you consult with your local attorney when drafting your policies. Until recently, courts had generally found that employers are not required to accommodate an employee's medical marijuana use. Massachusetts has one of the leading cases involving medical marijuana use in the workplace context. And let's discuss this case for a moment. It's called Barbuto versus Advantage Sales and Marketing. So this decision, decided in 2017, involves Christina Barbuto. She suffered from Crohn's disease, and in accordance with Massachusetts law, she legally used medical marijuana to treat her condition. She accepted a job offer with Advantage, which required her to take a pre-employment drug test. Before taking the test, she told the company she had Crohn's disease and used marijuana to treat it. After starting work, Ms. Barbuto was informed that she had tested positive for marijuana, and under the company policy, was terminated. She brought a handicap discrimination claim under the Massachusetts anti-discrimination law for Advantage's failure to accommodate a legal treatment for her disability, Crohn's disease. The Massachusetts Supreme Court held that notwithstanding that marijuana was illegal under federal law, accommodation of the use of medical marijuana was not per se unreasonable, and that at a minimum, Advantage should have gone through an interactive process with Ms. Barbuto to consider accommodations before it terminated her. Now, the Massachusetts Medical Marijuana Act provides, in part, that a patient using medical marijuana in accordance with its requirements shall not be penalized under Massachusetts law in any manner or denied any right or privilege for such action. The court found that under Massachusetts law, the use and possession of medically prescribed marijuana by a qualified patient is lawful as the use and possession of any other prescribed medication. And thus the court held that an exception to an employer's drug policy to permit medical marijuana use may be reasonable accommodation for the employee's disability. So the court noted, however, that at summary judgment or trial, the employer could offer evidence that medical marijuana was not a reasonable accommodation because it would impose an undue hardship on its business, such as significant safety risks. So the key takeaway from Barbuto then is that an employer who refuses to hire or who terminates an employee solely or merely because that person uses medical marijuana may face a claim of handicap discrimination. It's important to note here, again, that we're talking about a situation where it was pre-employment. You cannot, in Massachusetts then, refuse to hire somebody merely because they acknowledge or tell you that they use marijuana, nor can you just terminate or fire somebody when you learn that they use marijuana. It's interesting again to note that this claim was brought as a handicap discrimination claim. There is in Massachusetts no implied statutory private cause of action under the Medical Marijuana Act. And what that means is that unlike in some other states, Massachusetts has chosen not to, in the statute, address the issue of employers and employees. Remember, we talked earlier that typically the legalization of marijuana merely means that it's being decriminalized and that you can use it and possess it. It doesn't speak to the issue of what happens in the workplace. That's typically handled outside of the statute in states like Massachusetts. Other states have decided to address that specifically and have given employees specific rights or employers specific rights. Massachusetts has chosen not to, and that's why Ms. Barbuto had to bring her claim under the Discrimination Act. Okay, so what does this mean for you as employers? Legalization of marijuana does not mean that employees can be impaired at work. If you take nothing away, please understand that. Nobody's entitled to be impaired at work despite the legalization of marijuana for medical or recreational purposes. You need not accommodate marijuana use in any workplace, even if the employee has a medical cannabis prescription or the employer's place of business is in a state that's legalized marijuana for recreational purposes. Again, we're talking about use in the workplace. Barbudo addressed off-use, pre-employment testing, off-duty. In particular, employers may choose to adopt or maintain a zero-tolerance policy and may take action against offenders. So can an employer terminate an employee for being under the influence of marijuana at work? Always. Although it may be difficult to establish that a person was under the influence of marijuana, it is advisable to document all behaviors and witness testimony that the employee was under the influence of marijuana during work. Again, unless expressly provided for by statute, most courts have concluded that the decriminalization of medical marijuana does not shield an employee from adverse employment actions. And I've cited here a Michigan case just to highlight that. So in this case, the court said the fundamental problem with the plaintiff's case is that the Michigan Medical Marijuana Act does not regulate private employment. Rather, the act provides a potential defense to criminal prosecution or other adverse action by the state. However, as we noted, to recap, in Massachusetts law prohibits employment discrimination on the basis of medical marijuana use registration or identification card. As an employee, you must engage in an interactive process to see if a reasonable accommodation can be made in such circumstances. And as a practical matter, this means that if the employee is using marijuana with a medical card, employers cannot fire them on that basis solely. But again, remember Barbudo said that the employer can show or has the ability to show undue hardship. And so if you have a worker who's working in a safety-sensitive position, then there may not be any reasonable accommodation in such a case. If somebody's sitting at a desk, maybe that's a different situation. Let's switch now from marijuana to the opioid epidemic. You've probably read and heard on TV about the staggering numbers involving the opioid epidemic, and here are some of them. So 72,000 American lives were claimed by overdose in 2017. About 49,000 of those overdose deaths were attributable to opioids. And the biggest driver was the dangerous synthetic opioid fentanyl, which killed more than 29,000 people. Again, some staggering numbers. You note that the United States, which accounts for only 5% of the world's population, consumes 80% of the world's opiate supply. With the arrival of carfentanil and other fentanyl-related analogs, opioids that are 100 times more potent than fentanyl and 5,000 times more potent than heroin, the risks are significantly amplified. A fentanyl-related analog is merely a drug designed to mimic the effects of the original drug. According to an August 2018 report by the Massachusetts Department of Public Health, the state is currently experiencing an epidemic of opioid-related overdose and deaths. The estimated number of opioid-related overdose deaths in the state more than doubled between 2011 and 2015, and the rate of opioid-related overdose deaths is higher than the average for the nation. Massachusetts trails only Ohio, New Hampshire, and West Virginia. Fentanyl-related deaths in the state reached nearly 90% of all opioid-related deaths in the second quarter of 2018. According to the Centers for Disease Control and Prevention, the rising overdose numbers make the drug epidemic more deadly than gun violence, car crashes, or AIDS, which have never killed as many people in a single year. On the other hand, in parts of New England, where more dangerous supply arrived early, the number of overdoses has begun to fall. And that was the case in Massachusetts, Vermont, and Rhode Island. Each state has had major public health campaigns and has increased addiction treatment. Preliminary 2018 numbers from Massachusetts suggest that the death rate may be continuing to fall. All right, so what does this have to do with the home building industry? Well, here's how one source described the opioid epidemic and the construction industry. Opioid use and abuse among construction workers has become the industry's silent crisis. It frequently begins with pain, typically from job site related injuries, including falls or from tasks involving repetitive motion. Excessive exposure to vibration, in addition to bending, twisting, and awkward postures, inflicts hard wear and tear on backs, knees, shoulders, and other joints. And then the cycle of seeking relief for those ailments begins. Due to the ready availability of pain-relieving narcotics, the U.S. construction industry is trying to reverse a serious problem with opioid abuse among its workers and trades, a complex downward arc that results in further job injuries, shoddy craftsmanship, property damage, loss of productivity and profitability, even death. Dependence on prescription opioids can happen after just 5 days. And as you can see, the average construction worker addicted to opioids has been on pain medication for at least 6 months. The fatal overdose rate among construction workers is 8 times what it is in the greater population. According to the National Safety Council, 3/4 of those struggling with addiction to alcohol, pain medication, marijuana, and other substances are employed. Workers with substance use disorders miss nearly 50% more workdays than their peers, up to 6 weeks annually, and absenteeism leads to loss of productivity. The report by the Massachusetts Department of Health also found that construction workers are at the greatest risk for opioid overdose deaths in Massachusetts. Using death certificate data from 2011 to 2015, the study found that the opioid-related death rate for those employed in construction and extraction was 6 times the average rate across all Massachusetts employees. Clearly, this issue affects the bottom line. You can see right here, construction workers with untreated substance abuse disorder cost an employer $6,800 per year in excess health care, expenses, absenteeism, and turnover. But when a construction employee is in recovery from a substance abuse disorder, contractors save nearly $2,400 per year. And research has confirmed that opioids are not more effective than non-opioid painkillers for most pain. According to a November 2018 report by the Massachusetts Taxpayers Foundation, the impacts on business are severe and growing. Lost productivity from absenteeism and presenteeism is likely more than $2.5 billion annually. And that figures in addition to the excess healthcare costs related to opioid usage, estimated to exceed $2 billion. Additionally, difficulty filling positions is exacerbated by the opioid crisis. For example, the state recently experienced the unusual situation of having more jobs available than unemployed people. Massachusetts employers are already facing demographic challenges that are made worse by the opioid epidemic. The birth rate in the state is among the lowest, if not the lowest in the country. In 10 years, Massachusetts will have an estimated 200,000 fewer worker-age people between the ages of 16 and 64. So what can you as an employer do to make a difference? Well, you can take these steps. Recognize prescription drugs impact the bottom line, as we discussed. Enact a strong company drug policy. Expand your drug panel testing to include opioids. Train your supervisors and employees to spot the first signs of drug misuse. Treat substance abuse as a disease. Leverage employee assistance programs to help employees return to work. Drug-free work programs, including the scope of drug testing, the handling of positive results, and policies about prescription drug use in the workplace need to be revisited. You should consider, if you haven't already had one, establishing a written drug-free workplace policy that articulates the requirements and expectations of employees regarding substance use and impairment while in the workplace. Effective programs should consist of these 5 components: a clear written policy, employee education, supervisor training, drug testing, and an employer assistance program. Here's a sample policy. I think given the level of detail here, maybe it's worth reading in its totality. So let me just go ahead and read. It's a violation of our drug-free workplace policy to use, possess, sell, trade, and offer for sale alcohol, illegal drugs, or intoxicants. Prescription and over-the-counter drugs are not prohibited when taken in standard dosage and or according to a physician's prescription. Any employee taking prescribed or over-the-counter medications will be responsible for consulting the prescribing physician and or pharmacist to ascertain whether the medication may interfere with the safe performance of his or her job. If the use of a medication could compromise the safety of the employee, fellow employees, or the public, it is the employee's responsibility to use appropriate personnel procedures, e.g. call in sick, use leave, request change of duty, notify a supervisor, notify a company doctor, to avoid the unsafe workplace practices. The illegal or unauthorized use of prescription drugs is prohibited. It's a violation of our drug-free workplace policy to intentionally misuse and or abuse prescription medications. Appropriate disciplinary action will be taken if the job performance deteriorates and or incidents occur. And this is taken from the National Safety Council. Just want to go back to the use of the word illegal drugs there in the second sentence. Illegal drugs probably should be defined here, and they can be defined as those banned under federal, state, and local law. And the reason you want to do that is to avoid conflicts regarding marijuana's legal status in Massachusetts. Consequently, if somebody were to use the drugs in Massachusetts, given that your definition would include illegal drugs under federal law, they wouldn't be allowed to use marijuana. Manager or supervisor training should include examples of typical behavioral and performance-related signs of impairment. I'm sure many of you are familiar with employee assistance programs, but for the benefit of those who might not be, an employee assistance program, or an EAP, is a work-based intervention program designed to assist employees in resolving personal problems that may be adversely affecting their performance. EAPs have traditionally assisted workers with issues like alcohol or substance abuse. However, most now cover a broad range of issues such as child or elder care, relationship challenges, financial or legal problems, and wellness matters. These programs are developed and delivered at no cost to the employee, standalone EAP, or part of a comprehensive health insurance plan. Services can be delivered via phone, counseling, online chatting, email interactions, or face-to-face. 70% of all U.S. companies purchase employee assistance programs. Companies any size purchase an EAP service. Managers and supervisors are key to the promotion of EAP services, both initially and ongoing. All right, now let's talk about drug testing. A drug-free workplace policy was more easily enforced when illegal drugs were the only drugs banned under the policy. But now the increased use of prescription medicines, especially opioid painkillers, and the legalization of marijuana has created an important need to revisit these policies. So drug testing can occur at several points in the employment relationship. Pre-employment, as we saw in the Barbudo case, upon transfer or promotion to a certain position, upon reasonable cause being shown, post-accident, randomly, or following an employee's rehabilitation. Now, drug tests can be perceived as being highly intrusive. Employers conduct drug testing for reasons such as to reduce liability. If an employee harms someone on the job due to impairment, the employer may be legally liable for those injuries. Another reason is to maintain productivity and save money. We've talked a number of times now about absenteeism, tardiness, and job turnover have been found to result from marijuana and opioid use. Another reason that we have drug testing is to defeat workers' compensation claims. Now, importantly, a drug test does not prove impairment. It may show that an individual is using a particular prescription drug, such as an opioid painkiller, but it does not necessarily confirm that they're actually using or abusing the drug, that they're impaired by it or addicted to it. According to experts, determining the risks and levels of impairment from a particular prescription drug for each individual is almost impossible. Currently, there are no validated instruments, expert opinions, or guidelines determining context-specific impairments due to prescription medication. Before performing any drug testing or adopting a drug testing policy, employers should consult with a lawyer to develop testing policies and procedures. As we noted, drug testing involves an invasion of privacy. However, as an employer, you have a legitimate interest in prohibiting your employees' illicit drug use, particularly where safety-sensitive positions involved. Mandatory drug testing may be upheld as lawful if the reason for the test and the procedural safeguards accompanying it outweigh privacy interests at stake. Drug testing may be unreasonable to some employees, but reasonable as applied to others. Massachusetts does not have a statute regulating drug testing, and thus the parameters of drug testing have been established by the courts on a case-by-case basis. For example, in one case, the Supreme Judicial Court upheld the application of random drug testing to an employee who drove the company car 20,000 miles a year to protect safety and corporate property and to prevent corporate liability. However, the court struck down the application of the same policy to a technical editor of user manuals because the nexus between his job duties and harm was far too weak. And so that's an example of where it may be unreasonable to one, but reasonable as to another. So what do? Well, Massachusetts, the courts, as we noted, they use a balancing test. So the factors to be considered are as follows: whether the employer has experienced productivity or safety problems reasonably attributable to substance abuse among employees, whether the employer has provided employees with advance notice of a testing program, the employment status of the test subject, whether the employer has a reasonable cause to believe that the particular subject is impaired, or whether the employer has adopted procedural safeguards to assure the validity of test results and minimize the nature of testing. A prudent Massachusetts private sector employer will not randomly test workers in jobs that do not present critical safety or sensitive issues, unless required to do so by federal regulations. Again, drug testing is typically limited to reasonable suspicion. So how do you determine reasonable suspicion? Irregular behavior, substantial deterioration in work performance, physical symptoms, direct observation of drug use, a report from a reliable source that an employee is using drugs, evidence that the employee has used, possessed, sold, or solicited, transferred drugs while at work. So to be safe, you should consider having a well-written policy about drug use in the workplace. This policy should include discussing the disciplinary actions and circumstances leading up to them in the testing procedures. Employees should understand how the test will be given, when it will be given, and what drugs the test will detect. You should require the employee to read the policy and sign an acknowledgement that they have done so. for every drug test administered. Document why the test was necessary, how it was performed. Ensuring test results are absolutely confidential medical information is important. And finally, you should be consistent with your response to workers who test positive. All right, so to learn more about marijuana laws and their impact on the workplace, NHB has prepared the following 2 resources, and they're available on nhb.org on our construction liability and resources page. You will need your member number to log in. So we have a webinar, Dazed and Confused, the buzz surrounding legalized marijuana in the workplace. We also have a builder's guidebook, Marijuana in the Home Building Industry. As to opioid resources, NHB has formed an opioid working group that's currently developing a slate of helpful resources. We are going to focus primarily on prevention, treatment, and recovery and return to work. NHB recognizes that the home building industry is not immune from the effects of the opioid epidemic. The audiences for our resources will be NHB members, supervisors, home builders, workforce, and their families. The information will be delivered in different forms, toolkits and fact sheets, webinars and podcasts. The program is being developed. A program is being developed exclusively for executive officers. It should be available in January. The other resources that I discussed, many will be available in time for IBS. If you're looking for resources in the meantime, here are some sources for you. Massachusetts has provided some information on overdose prevention. You can also take a look at the Substance Abuse and Mental Health Services Administration, as well as the National Safety Council. So that is it, and thank you very much for your time and attention.
David, thank you. I went over at the Area 1 caucus. I thought it was fascinating. And I appreciate you doing it online. I have one question for you. There's a reverb, so I'm going to turn your phone up.
I'm sorry, Scott?
I have a question for you. I muted your phone for the time being because we're reverbing. You must have 2 mics open. But a question for you. Can an employer insist on an employee enter a rehabilitation program as a condition of employment because they've obviously discovered that there is some kind of abuse going on, and they can bring them in and say, you have to go to this program if you want to work here in the future?
Scott, the short answer is I don't know. I would think if you have a drug-free policy, if that's something like that is set forth in your policy, that you could do it. I think that since Massachusetts is an at-will state, that you can terminate somebody for any reason. So if you make that a condition and they refuse to do it, then you could terminate them. So I would think that you could make that a condition of their work. But I think the safe way to handle it is to have language like that in your drug-free workplace policy, so that an employee would know that that's a possibility.
I appreciate that. Thank you. And another question: now that there are several recreational marijuana shops open in Massachusetts, and more online to open, I think there's going to be a period of confusion in employees. Do you think there's going to be any kind of a vast increase in cases that are how to handle this from a employer standpoint?
Yeah, I do. I think that there's going to be a lot of confusion in the workplace about what it means now that marijuana is available recreationally, which is why I think it's so prudent that you're having a program like this, because there is confusion, particularly as it relates to the off-duty. I think it's pretty clear that whether you're talking recreational or medical, that nobody can be impaired in the workplace. I think the more challenging question is going to be as it relates to recreational, if people are doing this off duty, off site, what are the implications then for the workplace? That's where I think the challenge is going to be.
And here's a question, David, from our chat window from Maria. She says that Hound Labs claims they have invented a marijuana blow test. Any update on our testing labs using that soon to remove marijuana rather than past use? And second, I'll unmute your phone.
No, I'm sorry, Scott. I'm sorry, but unfortunately, I'm not familiar with that test, so I don't know how it stands up to the others. And as I noted, from everything I've seen, there aren't any reliable tests, but this may be one I just am not familiar with it.
Understood. So I'm going to unmute the phones. Anybody have a question? Feel free to chime in. Overwhelming silence. That's okay. I think we're having it's certainly a ever more confusing landscape. I do think that we're in a period of maybe diminishing use of the opioids now that they're not prescribing as many. It's going to take a long time, of course, and certainly we're going to have to do something about the amount of fentanyl that's being pushed into these drugs overall, because that seems to be the real killer. And
yeah, it's scary how powerful those fentanyl.
Yeah, it is. It's just not right. So with that, I'm going to say thank you, everybody. Appreciate it. And David, I really do appreciate you coming on board today. And with that, we'll close the webinar. Have a good afternoon.
Thank you, Scott. Bye-bye.